Well, let's start. Good morning again, and thank you for joining. Today, we're going to discuss about financial abuse, but also about financial abuse service from Richmond Legal Center, just exploring our holistic, multidisciplinary service for our victim survivors across New South Wales. My name is Maral. I'm the financial abuse service community engagement worker here at Richmond Legal Center. And just before starting today, I would like to acknowledge the traditional custodians of the land on which we're meeting on today and pay my respect to elders past, present, and any Aboriginal colleagues with us here today online, or they'll be watching the recording later. For today's webinar, we're going to discuss intimate partner financial abuse. We're going to introduce our panel members from Financial Abuse Service. We're going to go through a couple of scenarios, kind of an interactive sessions with the panel members and getting Q&A from the audience online through the chat. And I'll let you know whenever the chat is on, so you can pop in your questions to specific panel members, to the specific scenario, or even if you have general questions towards the end of the webinar. We'll start with intimate partner financial abuse. So intimate partner financial abuse or economic abuse is a form of domestic violence. It often occurs in intimate partner relationship where one partner uses money to gain power and to control their partner or ex-partner. It is not just about specific behaviors of financial abuse that perpetrators do, but also the intent behind these behaviors impacting victim survivors' financial security. Financial abuse can happen to anyone, regardless of age, income, or even their financial capability. And our service specializes in intimate partner financial abuse support, and we'll discuss it more today with our panel members and throughout this session. Some behaviors of financial abuse are the day-to-day controlling of perpetrators, controlling victim survivors of their spending and any other personal items that they buy, controlling the household finances, making victim survivors accountable for every dollar that they spend, and punishing them for spending the money the wrong way. Sometimes controlling the household money and giving victim survivors insufficient allowance, asking them to meet their needs, personal one, but also other bills and household payments. Another form or behavior is denying any accumulation of assets, and usually happens when they're separating and victim survivors are seeking either spousal maintenance or child support. So usually perpetrators would erode these assets or deny any accumulations of it. Perpetrator would coerce victim survivors to take out debts and loans in their name or in joint names and refusing to contribute to the payment of these debts, usually without their consent or even their knowledge. Blocking access to social and economic participation, usually denying and restricting victim survivors' access to phones and communications, even access to their family or friends, isolating them from even seeking support, whether that's from a lawyer or a social worker or any other services. Another form is harassing victim survivors at work and jeopardizing their workforce participation and not allowing them to work and to be financially dependent on them, so they don't have their freedom. Financially monitoring and refusing to also contribute to household costs, refusing to contribute to the material needs of children, kind of punishing their partners by punishing the children by not meeting these needs. And finally, exploiting women sexually in exchange for money, and that would look like in different forms by either wanting pictures or even any other sexual acts for money or other means of needs that the victim survivors might need. I would say other details to be looking for if usually you're facing clients or you're screening clients for financial abuse is that it can be disguised sometimes as a financial hardship that the victim survivor is going through, or it is accepted as a part of cultural or financial arrangement that they're having. Usually, it doesn't end with the relationship, especially prior to seeking support. Consequences can continue for years for victim survivors, especially through negative credit score or eroded financial security. And we'll understand more when we go through the scenarios today. The last part would be it's usually when clients are fending for themselves prior to seeking our service or any support. So they would usually end up taking out loans or any other ways just to cover their living expenses. I will now move on to introduce the rest of our team, and I will hand it over to Claudia.
So, hi everyone, I'm Claudia Robinson. I'm the Senior Solicitor in the Financial Abuse Services, Credit, Debt and Consumer Law team. So I've been working in community legal centres for a few years now, and I joined Redfern's FAS a couple months ago. So what we look at in my team, so we support victims, survivors who have been impacted by financial abuse involving loans and other debts, just for example, personal loans, credit cards, car loans. Often we see clients who have been coerced into borrowing money for the perpetrator, or the perpetrator has perhaps even taken it out in their name without their knowledge. And we've also seen clients who have been coerced into making personal guarantees for the perpetrator's company that they're running, despite having no role in running that company themselves.
Thank you, Claudia. I'll move on now to Julia from Company and Tax.
Hi everyone, good morning. My name's Julia McClelland. I'm the company and tax lawyer in the Financial Abuse Service at Redfern Legal Centre. So similar to everyone else in the team, seeing people who've experienced intimate and family and intimate partner domestic violence and financial abuse. In my service, we primarily focus on company and tax issues, helping victim survivors who have potentially different tax debts that they're unaware of, or that they've kind of been coerced into by the partner. If they're involved in a company structure, they may be a director, and there can be different notices, from the ATO that they are issued for outstanding debts in that respect, and then also giving general advice about director duties and different personal guarantees which people may sign for loans of companies that then default.
Thank you, Julia. Catherine?
Morning, everyone. My name's Catherine Liebel. I'm the Senior Family Lawyer in the Financial Abuse Service. In order to get through to the door to speak with us, then the client needs to have experienced financial abuse from an intimate partner. And me and the family law team tend to give a lot of initial advices about clients about what they would be entitled to under the Family Law Act. We also do a bit of casework for clients. It's important for you to note that we do not represent in court, but if you have a client that is capable of self-representing, then we sometimes do a bit of, for want of a better word, ghostwriting for clients. And we'd advise about property, about parenting, spouse maintenance, divorce, and any other aspect of family law. We generally won't speak with someone if there's only a parenting or a child support issue, simply because there are other services available, and we prioritize people who need property law advice because it's, I suppose, a bit of a unique service in that sense, because there are not many services out there that give free advice for property. And I'm happy to answer questions later on if anyone has any.
Thank you, Catherine. Gillian?
Hi everyone, my name is Gillian White. I'm the Senior Financial Counsellor in the FAS team. I primarily work with representing clients with creditors, and I assist them in getting outcomes for debts that have been occurred in their name, either through financial hardship or through coercive control by their partners. I also work with clients to help them future-proof their finances. So I'll do some budgeting with them and some future planning as well. Thank you.
Thank you, Jill. And finally, Christy.
Hi, I'm Christy. I'm one of the social workers in the Financial Abuse Service. So we have two social workers here at FAS, and we work with clients who are needing social work support and receiving some kind of legal advice from FAS. We can provide either sort of discrete one-off support to clients or ongoing holistic case management, and that can include safety planning, referrals and advocacy, and completing applications such as victim services and housing.
Thank you, Christy. And just before we move on to our scenarios and interactive session for the day, this is just the eligibility criteria for our financial abuse service. I believe many of my colleagues did mention the financial abuse from an intimate partner, but also the specific criteria for each practice area, especially if clients are only seeking help for property settlement and kind of doesn't sit with the criteria. However, our criteria is if a client is experiencing financial abuse from an intimate partner, they're having legal issues within the expert area you just heard about and you'll hear about, and if they have any connection to New South Wales. And within that, it means even if the client currently is not living in New South Wales, living in another state in Australia or even overseas, but their legal matter or legal issue happened with the partner or ex-partner in New South Wales, then our service would be able to help. Our service is also free and confidential, providing those expert areas in legal, financial counseling, and social work to assist people in all of New South Wales experiencing any money problems from an intimate partner. We also have, we don't have it in-house as an expert in migration, but we do have partnerships with IARC, with Immigration Rights Centers, to help clients that are basically going through financial abuse from an intimate partner and those that are on partner visa. So even though there are some practice areas that are not in-house, but we do have different partnerships and pro bonos with other places. And now we'll start with our first scenario. I'll read out the scenario and then we'll ask a couple of questions. Just an FYI for everyone, the chat will be open while I'm going through the scenario and the Q&A feature. So you can put in your questions while I'm reading the scenario or even when we're interacting with the panel members, and then I'll start taking these questions one by one. So the first scenario we have is Sarah and Remy. So Sarah actually separated from Remy a while ago, about 3 years ago. She has been receiving some overdue director penalty notices, or known as DPNs, from the ATO, chasing her and reminding her to pay her fees and tax for a company. However, Sarah is unaware of any of these companies. That looks like it's registered under her name and she hasn't signed up for. With our consultation, she suspects that Remy had forged her signature and maybe signed her up as a sole director of that company. So now as Sarah is being chased by debt collectors for other debts that are not related to the company, but also that Remy took under her name, and it's estimated around $12,000. So Sarah is seeking assistance from our financial abuse service for the debts that's from the company and tax, but also other unrelated debts. And I want to start with Julia for company and tax issues and being chased by the ATO for the DPN. So for someone like Sarah, Julia, how would she find out that she is being signed up as a director?
Okay, sure. So a situation like this, if a client's receiving a director penalty notice, that's a pretty good indication that they're a director, because the ATO has access to the ASIC company register, and will have people's names listed, and have access to all of that, so they can see who the directors of every company is. As Sarah said that she's unaware, I would definitely suggest, just to check all the boxes, the first step is probably doing like getting a company historic and current company search on ASIC. It costs about $20. It's very straightforward to do. The client can do this, and that will pull up, like, she'll know the name of the company because it will be on the notice, and that will pull up, exactly when the company was incorporated. It will have who the directors are, who the other office holders are, who the company secretary is. It will have a list of shareholders, and the times and when all this was done. So that will be able to give a bit of certainty about her position. If we had someone coming in who wasn't sure if they were a director, didn't even know the name of a company, we would recommend that they undertake a director name search through InfoTrack. It's about $50, and that allows you to search your name across the ASIC register and see what companies you're showing as a director for. So definitely the first step will be that. However, she probably already knows because she's been issued the director penalty notice, and we would have to look into steps of how to get her annulled, which is a process to do that, getting her directorship annulled if in fact she had no knowledge and it was, he just forged a signature and it was a situation where this is a complete fraud.
And for a situation like this, Julia, be like knowing she's being signed up as a director or sole director of a company and the debts that she's being chased off, but also what are some of the risks and liabilities for victim survivors in these situations?
Well, one of the main risks is exactly what's happened in this situation, which is being issued with a director penalty notice. So, as I'm sure everyone knows, a company is a separate legal entity to the individuals that sit behind it, to its directors. So, directors or shareholders are not automatically liable for debts of the company. However, there are a few exceptions. So, firstly, if a director's signed a personal guarantee, and then the company defaults on that loan, the creditor can chase the individual for those funds, which we see happening quite a lot. And often people, you secure company loans against their family property, and then there's a default, which is problematic. Also, in terms of taxes, so while shareholders or a director's not going to be liable for your company tax in the entity, because that's all that's kind of separate. There's a corporate veil that shields them. There are 3 types of taxes that the ATO can issue a notice, and then the taxes are attributed personally to the director. And so that's what's happened here, and that's what happens through director penalty notices. So those taxes are GST, and then superannuation guarantee charge and PAYG withholding. So you can kind of get a sense by the types of taxes they are. It's kind of to try and protect employee entitlements. Even if a company kind of, goes into liquidation, or it's encouraging directors to make sure they're complying with their employee obligations and entitlements, because there are personal risks to them if companies don't do that. So, often we see situations where husband and wife, they're both down as the directors. It's husband's running a company, or even the wife could be involved as well. Anyway, there's an incident of financial abuse. It could be linked to, addiction issues, gambling. And what's happening is the company's not complying with its tax obligations. It's not remitting super for its employees or contractors. And then, debts are accruing in the company. And then the ATO will issue, after a certain period of time, a notice to the directors. Often the wife might not have any knowledge of what's been going on if she's not super involved. However, she's still been issued this notice, which is a huge risk for people. The timeframes are very short as well. You've got from the day the notice is issued, the company has 21 days to either pay the debt or to liquidate the company, or the debts are personally attributed to the individuals, and then the directors will see them on their tax accounts personally. There are defenses that we can run and that we can put to the ATO. There's things about, if a director during the relevant period when the debt was incurred, they didn't have or they couldn't exercise management and control as a director of the company, due to illness and or any other good reason. And we try and put submissions forward that financial abuse and domestic violence it does fit that and or any other good reason. And, we have had some success with the ATO with those types of submissions. However, I would say, there's a very, very high evidentiary burden. Obviously, there's significant debts. The ATO needs to be satisfied the defense is really met, which they rely on, very strong evidence to do that, which sometimes is, again, problematic with victim survivors. They might not have gone to the police. They might not have contemporaneous evidence. And in those cases, we have to advise that prospects are pretty slim, if the evidence is not there of trying to be relieved of these types of debts. As I also touched on, there's, the issues with the personal guarantees. There's also, obviously, your director duties. There's a range of fiduciary duties and also duties within the Corporations Act that directors need to comply with. So I give advice to clients about their obligations as a director, as sometimes they're not that well informed. So yeah, I'd say overall that's probably I guess the scope of it.
Thank you, Julia. And I think you highlighted a couple of stuff, and something important also to note is the time limitation that we have. And sometimes even if there are some options with the ATO, but it will depend on each situation and circumstance, even within the issue of like financial abuse and the victim survivor going through it, but not knowing about the company, sometimes it might not advantage them, and it might make them to take some options or some pathways that they're not happy with just because of the time limitation that we have. But at least it's good to know there are defenses and there are some ways that, and of course, more ways that you're always helping clients with.
Sure. Thank you. Yeah.
Julia. I want to move now to Jill and talk a bit about financial counseling in this situation with Sarah. And since now we talked about the company and the debts that she's being chased for the fees, but also she has some debts that are not related to the company, and it's big amount of money, $12,000. So I guess I want to ask you, Jill, how do we find out what debts exist in this client name? We all know the number, but we don't know how they are related or not related and what's happening.
Yes, so what we would first do with Sarah is we would ask her to send in any emails or letters that she's received from debt collectors to see what those debts are and who originally raised those debts. We'd also ask her to get copies of her credit reports, because her credit reports should show us what's been applied for through the inquiries part of the credit report, and then it'll also show us what debts have actually been taken out. There are some debts that won't appear on a credit report, but it does give you a fairly comprehensive overview of what the situation is for the client. It would also show her directorship on the bottom of the credit report, and it would show us if there were any company debts that she had signed personal guarantee for that had defaulted, as that would show up on the credit report as well. And then we would be going through the list of those debts with the client to see what happened and gather all the information. That would be our first steps with her, to see if she knew about any of the debts, to see if Remy just took her ID and applied for the debts, or if he kind of coerced her or threatened her to taking out those debts as well.
And in that way, after understanding what kind of debts and kind of the creditors that are seeking to get this money, after this resolved, and I know it takes a long time to find each one, and then either getting a waiver for it or negotiating the debt, how would that actually be decided with the client, and when it's appropriate for you to kind of negotiate this debt, or is it going to be waived, or kind of escalate these disputes if there are no response, or a response that you would like, Jill?
Yeah, so we would get an authority form for each of the debts that the client is aware of or that we've managed to find through our searches. We would then go about contacting the creditors, and we would be asking them for all the documentation. So we'd be asking them for the assessment that the client filled out in order to gather the loan or credit. We would then be asking the creditor to also provide statements so we can see how the money was used. If the money went directly into Sarah's bank account, we'd ask her for bank statements from around that time to see if the money was moved into her bank account and then straight to another bank account, so that we gather some evidence to prove to the creditors how this money was used. And then it would depend on whether the client had benefit from the debts or whether they were solely for him and he just took the money and used it. And then what we would do is we'd go through options with the client. So there's always the option to do nothing. She can decide that she doesn't want to do anything. Financial counselling is very much client-led. So we go through every option. There's payment arrangements, there's waivers, there's bankruptcy is always an option. So there's multiple options that are available to a client, and then we would go through all the pros and cons of each of those options with the client, and then she would decide what she wanted to do. If her decision is that we're going for waivers, say all the debts were forcibly taken out in her name by him, we would then write to each of the creditors, explain the circumstances of what's happened, explain the financial abuse and the domestic violence that's occurred in the relationship, and we would ask for the creditors to acknowledge that and provide waivers for the client. If they choose that they don't want to then waive that debt, we go through the dispute resolution process. So that starts with an internal dispute with the creditor. If again, that does not resolve the issue, we often have escalation points within our creditors that we can talk to senior staff through the Financial Counsellors Australia toolkit that we use to contact creditors. And if that doesn't resolve it, then we have our external dispute resolution. So it depends on what the debt is. If it's a telecommunications debt, we'd be going to the TIO. If it's a credit card, then we'd be going to AFCA to explain the client circumstances and ask them to rule in the favour of the client, because the client has been very vulnerable and has been affected by financial abuse. So that is the process we would go through to assist the client in these circumstances.
Thank you, Jill. And I think that makes it clear, at least for people to also understand what kind of options they have if they're trying to communicate that with a client, or even to know if they should be referring a client to financial counseling. I think I'll start taking some questions from the Q&A, and
I can see the first one, Morel. I think that
Yep.
kind of relates to tax debt, so I'm happy
Yep.
to speak to that.
Yep.
Yeah, sure. So I might read the question out for everyone to hear. So the question is, I think this is because I was talking about potential defences to director penalty notices, and somebody's asked, does it have to be domestic violence? I have a client who is a victim of violence and is being pursued by the ATO. She is unable to perform her work duties due to an injury sustained, which is affecting her ability to repay the tax debt. In terms of that, look, so there's different types of tax debts. Also, there's different types of taxes, and we also have to look at like what entity, is the debt in the individual's name, is it in the company's name, So initially, I'd say look at all that. If it's in regards to a director penalty notice, so a debt of a company that has, that's either related to GST, PAYG withholding, or superannuation, and it's been attributed, well, a notice has been issued and the underlying debt has then been attributed personally to a director. Yes, a defence, if the client suffered injury, it's not after the fact, it's during the period when the debt was incurred. So when the company should have been, remitting its GST or remitting its superannuation for employees, because the individual was injured then, she couldn't undertake her duties, that would be a defence that we could put to the ATO. If there's a situation, where it's not coming from a director penalty notice and it's just general tax debt that's in an individual's name, there are specific hardship provisions in the legislation where the commissioner can use discretion to no longer pursue a debt if it would put a person in significant hardship. However, I will say that it's a very narrow discretion and it's a very high threshold, and it's quite rarely used. I would say it's quite difficult to get out of your tax debt. Another option, which is more likely, would be like a period of non-pursuit while the person can't work, and then an extended payment plan going forward for them to be able to pay this debt off. And then in terms of referrals to us, if it doesn't involve domestic violence or intimate partner relationship, it wouldn't be something that we would help with, because it wouldn't fall in, as our intake criteria. However, the taxpayer could still, put a hardship submission in if that's relevant in that case.
Thank you, Julia. And I think there are a couple of questions again about the eligibility. Just with the eligibility, we can help. I'm referring to Shweta's question. So we do help people who are on temporary visa. We do help people who are citizens, permanent residents, undocumented. So usually there is no criteria if they're on visa or not, or even undocumented. We help everyone as long as it falls within that eligibility of experiencing financial abuse from an intimate partner, and then they will go through the intake process and will understand more about the story and if they're eligible for the service. But usually it's those three, and they don't need to have any visas or any being a citizen even.
Sure.
And that answers the same question, Sadie, that there is no mean test for the service except for the eligibility criteria I put up earlier. And there was a question again to Jillian about the eligibility criteria for financial counseling. It will be the same, but I'm suspecting that maybe you're asking specific criteria from Jillian's side about financial counseling. Did you want to answer that, Jill?
Yes, so for our financial counselling service, we do ask that the client has an income coming in, whether that be Centrelink, from employment, or cash in hand, just so that we can actually assist the client with hardship arrangements with creditors. It's quite hard to assist a client who has no income. However, we can also put in, especially if they're on a temporary visa and they're unable to access Centrelink, we can write to creditors and explain their situation. We cover all of New South Wales, so you can refer a client to us through our website, through our web form, and we're predominantly a phone service. So we do the majority of our work over the phone. However, if a client is close to Redfern and would like a face-to-face appointment, we can provide that as well. The only other criteria for the financial counselling is that they do actually have a debt, so that we can ensure that there's actually some assistance there. If they just need some general budgeting or some assistance with their finances, then we usually refer across to the Financial Rights Independence Hub to help them with that through Good Shepherd.
Yeah, I might also just chime in. There's one more question I can see coming from a person in the Northern Territory asking about making referrals if their local legal aid service has a long waiting list. And yeah, so just to add on to what Gillian said, in the financial counselling intake criteria for the whole service, the criteria is that the incident needs to have occurred, or like the debt needs to have kind of occurred in New South Wales, or the person living in New South Wales. We do help people who no longer live in New South Wales, but when they, got into the debt or the incident, it was happening here. So if it's not within New South Wales at all and no connection to New South Wales, we wouldn't be able to take on that client.
I think we can take one more question, but I would just ask from the audience, please don't put specific questions if you're thinking of a client, just because of confidentiality and just the small details you might give to a public webinar. Feel free to ask any general questions or specific to the scenario or anything that you have about company and tax, and later on for other scenarios, but just not specific about a real situation or a client. I think this question might be for Jill. It says, is there any way to prove forgery if it had been committed by user of violence to put victim under pressure and cause debts? Would you be able to communicate with the bank provided the loan under the name of the victim?
If the client is willing to make a police report around the forgery, then we do have a better shot of proving that. But if they're saying that their signature was forged by the client, then we can also look to take that to AFCA and talk to their scams and frauds team, as they're more willing to look into those situations to assist the client with the bank. However, we have pretty good relationships with most of the banking services, and we do heavily rely on trying to teach creditors that they should believe the victim survivor and that they shouldn't need a lot of evidence to prove that this debt was coerced or forged in their name. And so there's usually evidence as to where the money has gone that can help you prove that this was a forged loan as well.
Thank you, Jill. I think that's it. We're going to move on to the second scenario, but just quickly to remind you of our eligibility from the last slide. Anything that's not on this slide, then we will be able to help. It's just the financial abuse from an intimate partner. Sometimes that would not include elder abuse that happens from family members. Usually it's the son or daughter or other family members. It won't qualify them for the service. But other than that, again, no visa issues, permanent residency, citizen, the connection to New South Wales, as long as the legal matter or that connection happened in New South Wales, and the financial abuse. If the client is now living in a different state, different country overseas, our team will still be able to help. I will put at the end our contact details again if you would like to send the web form or to contact us to talk to us. But I'll have to move on to the second scenario. For the second scenario, we have a different one, which is Selena and Ted. So Selena has been separated from her husband, Ted, again for a couple of years. However, she's still experiencing domestic violence, and that includes the financial abuse and stalking from her ex, even after separation. She has been trying to divorce him, but can't afford the legal fees. Other problems showed up, as in her children attend private school, and Ted has stopped paying for school fees. So that now she's getting calls from the school that they're threatening to expel her children. She was also recently contacted by a bank claiming there is a car loan in Selena's name that she never heard before, and that she suspects maybe it's tied to a car that Ted bought or purchased a few years ago. So it's a bit of a complicated case here. So she's facing the school fees and for her children to be expelled from the school. She's being chased for other debts, including the car loan, and the continued DV and stalking from her ex. So Selena is coming to financial abuse to service to seek assistance on these multiple and complicated matters with safety concerns and enrollment risks for her children. Since this is a complicated case, I just want to kind of ask to the team and say, how would you prioritize usually? Which area will be helping for a client? Clearly, in this situation, she's distressed from facing debt. She's navigating DV, the financial disadvantage, but she's also unable to divorce. And I think it's kind of going to family law side. And maybe I'll start with Kath.
Sure, yeah, I'd probably take the lead on this one, I think, at least initially. So the very first question that I would be asking would be, are they all safe, given that there's ongoing DV concerns? I'd be checking to see whether the client is comfortable reporting things to the police, whether the police know about it, whether there's an AVO in place or anything like that to protect her and potentially the children as well. If there were significant safety issues, then the first thing that I would be doing would be referring them either internally to our own social workers or to someone like 1-800-RESPECT, just ensuring that the safety is absolutely paramount at all times. The next thing that I would be doing would be asking a whole lot of questions about what's going on. So I suppose the first one is, what is the client's priority? A lot of clients use the term divorce as a bit of a catch-all to mean parenting arrangements, child support, spouse maintenance, property settlement, as well as divorce. In actual fact, a divorce is simply the legal dissolution of the marriage. And there are a few things that a divorce does, but it could well be that the client's main goal is just the psychological win of getting a divorce and being separated. I would be asking whether there are parenting arrangements in place, and if so it looks like there may be DV concerns. Is the husband spending supervised time or any time at all with the children? And would that be in accordance with a parenting plan or court orders that had been placed in terms of parenting? If there were court orders or if there's a parenting plan in place, was this being followed, and are there any breaches involved? If the client was withholding the children from the husband on the grounds that she felt that they were unsafe, is she at risk of being subject to an enforcement application in court? Once I had the answers to that, then I'd be looking into things like whether there was a child support agreement, because if the husband has stopped paying for school fees, then it could be that that would be something that I would pass on to Claudia, because it would be a credit and debt issue. But it could also be a family law issue if the issue is that the husband has decided that he doesn't want to comply with a binding child support agreement, for example, or even child support departure orders that have been made through the Federal Circuit and Family Court. Once I had answers to that, I'd be looking into whether there were property orders in place. So what arrangements had been made about separating the matrimonial asset pool, including the superannuation. If nothing had been done and there were assets, then it may be that the client might be able to just wipe all of this child support, the school fee debt, if she managed to get a property settlement. Given that it says that she's struggling to afford legal fees, it could be that there is no money in the asset pool. It could be that the other side has, I guess, hogged all of the money, all of the assets from the relationship, and the wife has simply had to flee the relationship in order to keep herself and the children safe. I would be asking the client what her understanding of the asset pool was at the current date, that is the relevant date for a separation of the matrimonial assets. It's not about the date of separation, it's about the current date. So finding out if she knew what assets were in her name, what assets were in the husband's name, if there was still anything outstanding that was in joint names, is there a matrimonial home there that one of the parties was living in? Just get an understanding of what was going on there. It's not uncommon for our clients to come to us with pretty much zero understanding of the asset pool. So there are things that they can do to do some digging and find out. And it may be that they have no choice but to instigate court proceedings in order to understand what the asset pool is and get orders saying that the other party needs to disclose all of their financial information. If the other party's still refusing to disclose, then there are options for subpoenas and that sort of thing. But it's very, very helpful if they have an understanding of what's going on. At this point, I'd like to point out I guess, the policy decision in our team for not means testing anything. The reason that we do that is because it's not uncommon for clients to come to us where there is an enormous asset pool, millions and millions in the asset pool, but the client can't afford to go and buy sandwiches because they have no access to any of this money. There are things that they can do about this, either going to one of the companies that provides litigation funding, and often when it is a situation where there are assets, significant assets, then we would refer these clients to a place where they'd be able to get access to some of the funds in the property pool through one of these loans. If it turned out that the client had no access to any funds at all, then we'd probably be looking at an application for legal aid, and we'd assist the client with that application and just let them sit back and wait to hear from legal aid.
Thank you, Catherine. I think there is a lot of complicated stuff even within that question, even in the decision of how we're going to approach this and how the team can help with this situation. And I think it's going to make much more sense now that we dive into more the credit and debt, but also the social work with the school fees, and then even understanding the thing that you talked about with divorce and why and even understanding why a client would like to divorce and what it means to them. But I'll move on and I'll come back to you again, Catherine. Thank you again. I want to go with Christy, and maybe there's a lot of stuff that's happening with the continued DV even after separation, and that includes the financial abuse, but also the constant stalking from her ex. So my question would be, how would we balance, or how do you balance in your practice the urgent financial advocacy that we're talking about and the things that she's being chased for, but then again with her own safety and the safety of her children?
Thank you. So I guess as an interdisciplinary team, we would be guided by some of the legal and financial assistance that she's receiving to inform our safety planning. So looking at the things that might be occurring that could impact her safety. So, for example, if she was to commence divorce proceedings, is that something that's then going to place her and her children at risk? We're also guided by our clients. They're generally the experts in keeping themselves safe. They've worked in different ways to keep themselves safe throughout the duration of the relationship, and also guided by what their goals are as well. We'd be continuing to work with our clients to monitor and assess what the risk is at those different times and review that safety plan and how we might work with our clients to keep them safe. So that could include reporting to police, reporting breaches of ADVOs, looking at other safety measures that might be able to be implemented, and then also supporting clients in sort of those practical interventions around their safety plan.
Thank you, Christy. I'll get back to you again as there is lots of things happening here. I want to go to Claudia and ask maybe about this situation that we're talking with the car loan that she's not aware of, and the suspicion that it might be linked to another car that he purchased. So kind of in that situation, what options does Selena have in relation to the car loan?
Yeah, thanks, Morale. So this might be a bit similar to what Gillian has already gone through, but the client's options, like at this stage, I wouldn't be able to say definitively because we've got no information about the car loan. Is it a personal loan? Is it a business loan? What kind of documents does the lender have? Do they have anything that's signed by Selena? If so, is this actually Selena's signature? Is it forged? Perpetrators do often have access to their victim survivors, personal documents, IDs, etc. So it's not unusual for them to take those documents and then take out loans in the victim survivor's name without their knowledge. So would be starting there, asking for documents, figuring out exactly what's happened, and the options the client would have would depend on the answers to those questions. So if it is straightforward, so say it is a personal loan and it is Selena's signature, so perhaps her instructions do change and she does actually recall, oh yes, he did actually take me down to a bank to sign some documents. I wasn't really sure what was going on. Would want more information about that interaction. Did the bank staff talk to her separately? Did she or Ted, do or say anything at the bank branch that should have put the bank on notice that there was potential financial abuse occurring? And we can really just go from there depending on what the client's instructions are, potentially asking for some kind of financial hardship, even a waiver, similar to what Gillian was saying as well. We can look at the client's bank statements, if the money came in and was immediately transferred to his account. And we can even perhaps look at, should this loan have even been approved in the first place? We can also, tie in some responsible lending principles. Basically, banks and lenders do have obligations to check that credit is affordable. So we can even look at, was this loan, even serviceable for our client, even if she did want it and was aware of it. And that's something else we can have a look at as well. But I'd just definitely say that it is going to be very dependent on the client's circumstances, exactly how the loan was taken out, what information the bank had, was there a broker involved as well? Because sometimes they might have additional information, or that could even be another avenue of pursuit if the broker has also, perhaps acted incorrectly in this situation as well.
Thank you, Claudia. I'll start taking some questions from the chat, and then if we have time, we can ask more questions to all of the panel members. I think this is a question maybe for either Kath or, yeah, it's Kath. Are school fees included in child support or as a payment agreed upon on top of the child support?
So that one is the same answer to pretty much any question you will ever ask any lawyer anywhere. And the answer is it depends. So generally speaking, if you just go through child support, then they'll make an assessment that's based on the number of nights per fortnight that the child spends with each parent or each carer, and based on their income as well. However, there is a document or a couple of different child support agreements that you can enter into on top of the child support assessments. They're called a binding child support agreement or a limited child support agreement. I'm not going to bore you all now with what the details are because it would take me all day, but it can be that you can get an agreement that school fees will be paid as child support in addition to what's assessed. But it'll generally depend on you getting a child support agreement separately.
Thank you, Kath. And we have a question from Tia. It says, will the client who was still in the relationship with the person using violence be eligible for this service? And considering the violence is financial abuse, that usually I believe, and I will also give it to the team to answer from their experience, they would usually support, but then there's a lot of risk issues that would arise, especially if they're like in this situation with the credit and debt, if there are some stuff that the credit and debt lawyers or even financial counseling or other services that they would start to tap into, then the perpetrator might get notified or know that the victim survivor is trying to resolve these issues, which could cause some risk issues for them. Anything to add from the team about that question with supporting a client that's still in the violent relationship?
I might just add quickly to that, Morale.
Yeah.
In addition to, I guess, the safety concerns, it's actually very common for us to be advising clients who are still in the relationship, I suppose, to empower them about what their rights might be if they do separate, and to give them a bit of an understanding of what they might be entitled to under the law. And then I think it's important to point out that the family law jurisdiction doesn't actually kick in until the relationship has broken down irretrievably. But we certainly do advise clients and give them an understanding of what is likely to happen should they decide to separate.
Thank you, Kath. And here it says, can FAS support a victim survivor with a self-managed super fund? They were coerced to enter into with a partner. Do you have any advice about this? I found it to be a really tricky area to support women with.
Yeah, this one's probably for me.
Yes.
It's definitely a difficult area. It's a super prescriptive and complex and very technical area of the law. Like there's a lot of things about, setting up supers and then super funds. And then there's also a lot of regulation to ensure that SMSF is compliant. Year on year, they have audit requirements. So we work with a pro bono accountancy firm that can help provide phone advice to clients on this topic. So if you want to refer them through, if it's suitable, we could set up a phone advice where I'd be on the call and the pro bono accountant, and we could go through some high level advice for the client.
Thank you, Julia. There is, I think, one more family law question is about how can the victim survivor get started to ascertain the asset pool without money, as obtaining litigation funding is dependent on the asset pool, and to get that point, it takes a lot of money or dollars.
Yeah, it can be a bit of a catch-22. I would always be starting with what you do know. So the client will usually have some kind of understanding about what they have in their name. If they don't, then I'd be running credit checks to find out if there's debts, and then maybe going and approaching the banks where the loans are, because sometimes it can be a bit of a sort of, I guess, a PI sort of detective role where you would ask the client, okay, well, if you've got a loan with this particular bank, perhaps there's an account with that bank as well. So go to the bank, ask them if there are any accounts in your name. And then if that all fails, then what I would probably do would be to start by writing to the other side and just write them in an initial letter saying, under the Family Law Act, you have an obligation to disclose all of these, all of your financial circumstances. And then if that fails, then normally I would be encouraging the client to write a notice of intention to commence proceedings in the Federal Circuit and Family Court. That often works and you get some sort of response, and then it may be that they have no choice but to actually start proceedings in order to get orders for the other side to provide their financial disclosure material. If they have no idea about the asset pool at all, then it's likely that they'd get some sort of legal aid. I think that comes with a caveat, of course, but there's a good chance that they would get some sort of grant of legal aid to be doing these documents and getting some kind of information.
Thank you, Kath. I think we'll take one more question, and I think it will be, and I had a similar question to that as well, because I'm interested about the school fees, and it's the elephant in the room. There is a question that says, is there a credit and debt lens that could be applied to the school fees, acknowledging that it's not a consumer credit under the NCCPA? I guess there's that balance again within the team of when there are multiple practices and you have social work, but you also there's that credit and debt lens. And I want to hear both from Christy and Claudia about how would you decide what would happen with the school fees, since when we're talking about school fees, it's basically money. So yeah, I want to hear from both of you. With well, it's 12 p.m., but we do have a couple of minutes if people are interested. Maybe Christy can go first.
Sure. So in terms of assisting with school fees, it's something that social work has done before and can do. Generally, from a social work perspective, we would be providing perhaps evidence of the domestic violence and financial abuse and the financial hardship to advocate to the school to try and waive those fees. We can also attend, help to speak to the school with the client, or attend a meeting with the school if that would be helpful to try and get the debt waived.
And Claudia, how would that, if we want to put a lens of self-credit in debt, how would that look like?
Well, what we'd be able to do, and I guess this really highlights one of the benefits of our service, is that we do have, a couple of different people who would be able to help in this down a couple of different ways. But what credit and debt, and when it would come to us, we would be more stepping in if there was threats of imminent legal action. Perhaps negotiations have failed, or the client just hasn't been responding to the school, and now they have either started legal proceedings or they are threatening to. So we would at least be able to advise about the court process, potentially if the client does have a defence, probably unlikely. The main thing we'd be looking at is, has everything been calculated properly? Is this the actual amount that we are looking at? And we can perhaps assist if there are court proceedings on foot and the client does agree that they do all of this, do owe the amount claimed, and they're trying to negotiate a payment arrangement, but they're not having a lot of success doing that. There are ways to apply to the court to have a payment arrangement stamped by the court, and then the creditor does have to stop pursuing if the court does agree to the client's proposed payment arrangements. That would be more what we're stepping in for, and then also obviously advising the client about what could happen if they do decide to do nothing, what enforcement action the school could take as well.
Thank you, Claudia. And that actually came to a full circle with all the practices, and even within this scenario. Sometimes it's more complicated cases and more complicated issues that whatever we share today with the first scenario and second scenario will be a blend of that, and all of the team would be scratching their head trying to figure out how to work this out. But this was just a snippet of how multidisciplinary and interdisciplinary service works, helping victim survivors. Just before ending today, we would like to hear from you how we did, how was the webinar. There is a link for the survey in the chat that will be sent. And also you can scan the QR code, but sometimes scanning might not work, so accessing the link might be easier. Once everyone's scanned, I can also at the end just one more slide to show our contact details, and then the link to our website and to the web forms. So if you have any questions, or if you have client in mind, the best and the safest options would be always to send in a professional web form after getting consent from a client, and send their details, and our intake officer would be able to help with that, and tell you if they're eligible for the service or not, or tell the client. But I would say, instead of going back and forth or calling or emailing, just send the web form. These are our details if anyone would like to take a picture, and I'll go back again to the QR code so you can scan it in case you didn't. And these slides will be published, and the recording of this webinar will also be published on the RLC website. Anyone who's interested, we can send them the link later, or they can access it through the website. Thank you very much. If you still have any questions that maybe we weren't able to send or ask them here, again, feel free to give us a call if it's a general question. Yeah, that's it for us. Thank you, everyone. And thank you for the whole team for today. Such a great interactive session filled with really exciting questions and discussions. But thank you very much, and I'll see you for the next one.